Hi, David Brannen here. Welcome back for another episode of Ask a Lawyer Live. Today we're going to be talking about the concept of frustration of contract for people who are on long-term disability. Now, this is frustration of your employment contract, and we'll address the issue of whether an employer can fire an employee who is on long-term disability because of this concept of frustration of contract. Now, if you're worried about this, you're not alone. A lot of people are concerned about this. Often the terms get thrown around about frustration of contract, what people's rights are. So we're going to break it all down today and hopefully dispel some myths and help you understand what your rights are. All right, so let's dive into this thing. Let me bring it on up. And just 1 second, I have to ask my wife for some help. All right, because I just started the show, of course, my dog wants to go out. So we'll let her take care of that and we'll just carry on. So let's dive in here. Frustration of contract. So what is it? It is a legal doctrine. That just means a legal, like a law, that applies when something unexpected makes it impossible for the employment relationship to continue. In disability cases, that unexpected event is usually a medical condition that makes it unlikely or certain that the employee will not be able to return to work. It's not a temporary thing, but it's permanent or long-term. Now, this isn't about fault. So when it comes to frustration of contract, it is not about misconduct. It's not about being fired. It's basically a legal way for the employer to end the employment contract because continuing it would be impossible in the circumstances because the person with disability can no longer do the work. Okay. Now, frustration of contract can appear in any type of contract, and the law recognizes it that sometimes, no matter what your contract is, you've made a contract to buy a swimming pool from a company, and a meteor lands on the swimming pool company's whole lot and destroys everything, and they go out of business. Like that would be a situation where there was a frustrating event that's nobody's fault. It's like a meteor out of the sky. So in those type of situations, employers let people walk away from contracts. Okay. Now, in the situation of employment, though, it is usually that the most common frustration is going to be disability. All right. Long-term disability and frustration. So how does it affect someone on long-term disability? So if you've been off work a long time, usually over 2 years, but it's not exclusively, your employer may argue that the contract is frustrated because you're no longer able to perform your job in the foreseeable future. Now, once frustration occurs, it is something that the law will dictate happens automatically. It doesn't require anyone to do anything, but there will be a time, and you can often look back at it and say, okay, when did the medical records, like there will be a time that the court would review the whole record and determine this is the date where the frustration occurred. Now, it doesn't mean you've been fired for a cause or that you've done anything wrong, and it's critical to understand that it is not termination for just cause. Ooh, I'm going to sneeze here. Oh boy, sorry, folks. The sneezes are coming on. Now, a concept to keep in mind is that a frustration of contract is not the same thing as a just cause for dismissal. Now, just cause for dismissal requires some type of wrongdoing or misconduct, implying that the employee has done something wrong. Frustration, especially in LTD claims, because it happens because of illness or injury, things that's nobody's fault, that is nothing that you could have done to prevent it. Courts have been very clear that disability is never a just cause, and an employer who claims otherwise might be violating human rights laws and things. Okay, so just keep that in mind. Now, when deciding when something is a frustration or not, courts look at a few factors. Again, it's not automatically just because you've been off 2 years that it's now frustration. That is an indicator in a lot of cases, especially with long-term disability, but it is not the be-all, end-all. They will consider how long you've been off, what medical evidence shows your condition is permanent or long-term, whether there's a realistic chance of you returning to work, whether the employer could accommodate you or reasonably wait longer. So part of the accommodations would be making changes to your work schedule or the work environment, or an accommodation might be just waiting longer to give you more time to recover. It is very fact specific and evidence based. It's not automatic. And it is important to know that the employer actually has to be the one to prove that a frustration has occurred. That is not something easy for them to do because they don't have access to all your medical records. So the employers will rely on you to provide them with medical evidence that they can then use to claim frustration. Now, you can't get cute and just not give them any medical information and hope that'll be enough to prevent a frustration. The courts will also see through that. So you will have an obligation to provide them with medical updates about the likelihood of you returning to work, the prognosis of whatever your medical condition is, how likely is it that you can work in the future, how permanent is the disability, all that kind of thing. Once the employers have gathered enough information in support of the idea that you are permanently unable to do your job, then they will move forward with these claiming frustration of contract. Now, obviously, this comes up because of long-term disability. There are some myths and things I want to go through, some myths and misconceptions. So one of them is that if you've been on LTD for 2 years, you go beyond the 2 years, that you automatically will lose your job because of frustration. Now, the reason that happens is because typically for 2 years, LTD will pay you as long as you can't do your own job. And then if you stay on LTD past 2 years, LTD will pay you if you can't do any other job. So normally, like, that is a good indicator for an employer that they could probably claim frustration of contract, because you've moved past the point where you've been on disability because you can't do your own job. And now you're on disability because you can't do any other job. That's an indicator to them that they likely can claim a frustration, but it is not going to be always true. They still have to have medical evidence to show that even though you are past the 2-year point on your insurance plan, that there's no reasonable prospect of you returning to work in the near future. Sometimes people at the 2-year mark, there may be some still hope of recovery, just depending on the circumstances. And the doctors may be saying that there is a prospect within the foreseeable future they might recover well enough to return to their own job, even though they're on long-term disability past 2 years. So again, like, you want to watch out for employers who are trying to just rely on the fact that you have not come back. Like, if an employer just terminates you with no evidence saying they're doing it on frustration of contract, they don't have the medical evidence to back that up, and you haven't withheld medical evidence from them, that they could be in some trouble there in terms of proving that they've done what they needed to do. All right. So let's move on to the next one here. So what might you still be entitled to? If frustration is found, then you will lose the right to common law severance. And the bigger, this is the bigger payout that people usually get based on your age, years of service, type of job, and so on. That is when people think of getting severance pay, and termination pay, that is what people are thinking about. That's the big amount of money that you can get. However, even though you have frustration of contract, you still may be entitled to minimum notice under the Employment Standards Act of each province. So each province has minimum standards. And again, you'd want to consult on a case-by-case basis, but most provinces will allow you to be paid for minimum statutory notice, even though there's been a frustration of contract. This is something in Ontario. Ontario has made it explicit that they've added that to the regulations associated with the Employment Standards Act to make it 100% clear that that is the case. In other provinces, it has to be interpreted that way, but I believe most provinces have interpreted it that a frustration of contract would still entitle someone, for disability at least, would still entitle someone to minimum payments under the Employment Standards Act. Okay. Now, in most provinces, that's not going to be a lot of. It's going to max out at around 8 weeks or so, depending on how long. If you've been at the employment for 10 years or more, usually it caps out at about 8 weeks for most provinces, but you'd have to check into that depending on your province. But just keep in mind, you may still be entitled to termination pay under your Provincial Employment Standards Act, even if you're being terminated for frustration of contract. Now, keep in mind, if you're on LTD and you do get that termination pay under the Employment Standards Act, so the employer pays it out, it probably is going to be offset by your LTD payments. So you would get that payment, but your LTD would then reduce what they pay you by the exact amount, so you're no further ahead. Just keep that in mind. Again, that will depend on your insurance policy on whether that happens or not. Now, other things you're entitled to when you are terminated based on frustration of contract, there's other entitlements like vacation pay and accrued vacation pay that hasn't been paid out, that you could get that. I'm trying to think of anything else that you might be able to get, but I think that's pretty much it for employment standard stuff. And again, like I said, just keep in mind that most provinces do require the ESA minimums to be paid out, but there are exceptions. Okay. So let's move on to the next slide here. So some real examples. Now, in one case that we had dealt with, someone had been on LTD for over 2 years. The employer claimed frustration, but their doctor believed a return was possible within 6 months. Court would reject the frustration argument. Employment continued. Okay. Again, the 2 years is not automatic. It boils down to medical evidence. Now, often the medical evidence is very strong in your favor when you're at 2 years, and you want it to be strong in your favor because you want the LTD to continue. So it's often not in your interest to make ambiguous medical evidence in order to keep your job. If in fact you are totally disabled, that can cause problems with the LTD now not approving your claim. So you have to be careful there. Another case that I've seen was the employee had progressive degenerative condition and no reasonable chance of returning. The court upheld the frustration. Yeah. It will all boil down to context. They will look at the nature of your condition and what the prospects are in the future. And if you have a progressive degenerative condition, like multiple sclerosis or something of that nature, where it is getting worse over time, it's not expected to improve, those frustration will be upheld just based on the fact of your current level of function, and the prognosis of the condition can be enough. So the medical evidence is what is critical for or against. Again, you have to be very careful if you want to be on long-term disability for the long term and you're getting your doctor to write notes saying, oh, you could be better in 6 months. Like, that's the kind of things you would need in order to maintain your employment. But it can also, that same evidence would go against you for helping you prove that you're on should be on long-term disability. All right. So what should you do? If your employer claims a frustration, don't panic. it doesn't automatically mean you're going to lose everything. So, first of all, don't assume they're right. Many employers get this wrong. Many, 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 especially if they're not consulting their own lawyers. Some of the best work I do is create jobs for other lawyers because a lot of by holding employers' feet to the fire when they do things incorrectly, it will then make it better in the future that they will not do this type of thing again. So I do find employment cases are the type of case where you can make a difference just by doing your own case because you can change the culture within your company that they won't do this again to someone without getting their lawyers involved. Now, that doesn't mean they won't fire people, but they'll be less likely to go about it in the same way. Usually one lawsuit will change the behavior, not always. So get legal advice. If you're being offered something or nothing at all, be very careful about signing anything when they're claiming that there's been a frustration of your contract. Your LTD will continue. So this is people's worry that if their employment is terminated by frustration or otherwise, does that mean their LTD gets cut off? The answer to that is no. You may lose other benefits like group medical benefits, medical, dental, all that kind of stuff. But the open LTD claim that you have will not go away. You wouldn't be able to make a new LTD claim, but the current claim that you have remains open because you started it when the policy was in effect. Okay, so you don't have to worry about losing your LTD just because your employment ends. All right. It's Yeah. So sometimes it's not in your interest to fight the frustration in and of itself, especially if you are on long term disability and you want to be able to prove your long term disability going forward. It'll not be in your interest to challenge it. What is this dog doing? He's going to drive me crazy here. What are you doing? Get out of there. Get going. I don't know if you guys have dogs at home driving you. There we go. That guy. All right. Dude, we're recording something here. You can't be scratching around. Final thoughts. Frustration of contract is complex. Definitely complex. And it's increasingly raised by employers in these long-term disability cases because it's a way for them to just get people off. All employers are looking to downsize, right? And having people as employees who are still employees while they're not in the workforce, they're out off on long-term disability, they're always looking for ways to get those people off. And this is the best way to do it, frankly, for employers. So if you do get a letter claiming frustration, I would encourage you getting advice about that, and don't sign anything until you talk to a lawyer. All right. Well, thanks for joining me. Let me know if you have any questions about this topic. This is a topic that comes up over and over, and I'll probably have another session talking about this before too long because people are very interested in this topic because it comes up quite a bit and causes a lot of stress for people, for sure. Okay, let's move into this. So now I can take questions from people if you have any. I'm going to check, like I always do, what's going on the Disability Claim Forum. I can answer questions. Most of my areas of expertise are going to be around employment and disability law, but if you have other questions, I can take a stab at it. All right, this is a question we were talking yesterday. So let's go catch up on it. We answered this question yesterday, and it looks like the person has responded. So let's go see what's going on here. I'm just going to share my screen here. If you recall, if you were here yesterday, we were reviewing this one. They were wanting to know what it means what does it mean when your file is closed? And I had said, your file will be closed just means they're no longer paying your benefits actively managing your claim. You 100% have the right to appeal, and they will reopen your claim when you do the appeal. And I don't like this language of closing claims because I think insurers say that thinking that there's a certain percentage of people that will just shrug and say, well, I guess I'm done. Nothing I can do here. This claim is now closed. So that's what I don't like about this type of language. It's misleading. And this person also asked for, are they responsible for paying the update forms? So the insurance wanted them to get these update forms into them. And if they didn't get the update forms by a certain date, they were going to close the claim. So that's what's going on here. And the person wanted to know who pays for those update forms. Unfortunately, you have to pay for them as the insurance claimant, and that can be a barrier. So Bio was saying probably Canada Post and it went missing. You need to get your doctor to fill it out ASAP. Yes, you're responsible to pay. You'll likely permanent in this once a year update. Yeah, they're right. So probably once a year you have to pay for these forms. My insurance company's always paid for my doctor to complete my forms as part of my contract. Okay. So I guess you got to read the contract. Yeah. So people are all throwing in their things here. What if I cannot afford to pay? Maybe you can negotiate with the doctor. Any chance you can claim the fees from extended health benefits from employer? Yeah, those are ideas. They're saying send an email right away saying they were never received. Make sure you have the proper address on. They have your proper address. Yeah, every policy is different. So Buckets has always got good advice here. You have to pay the cheaper than losing your LTD payments if they close your claim. My LTD contract is silent on who pays. Yeah, if it's silent, it's implied that you have to pay yourself. Unfortunately. All right, what else do we have here? Something on child payments. So this one is about. Oh yeah, this is the one about. Yeah, this is the question the person had about what can they do about the children. They have an adult child now, 18, and who gets the money? Can the insurance claw it back? And again, Joanne is correct that it depends on the individual contract on whether the LTD can offset the child portion or not. It will depend on the contract. I wish I could do the little thing where you point the finger to say, yeah, this is correct. I don't really have anything to. I'm just going to say. So Joanne, am I spelling that right? Joanne. Joanne is 100% correct as usual. Yeah. Yep. So Joanne is correct. I think Joanne comments quite a bit on here and is very much correct. I don't know Joanne, but obviously knows a lot about the insurance industry and how things work. This person is asking for, I'm receiving CPP disability and will be turning 65 next year. The Service Canada website seems to say that my CPP and OAS will be paid in the month after I turn 65, but doesn't CPPD stop the month before I turn 65? Should I expect no benefits at all the month I turn 65? Okay, Joanne. Oh, here she is again. Let's put a heart already because I know it's going to be good. I have personal experience with this situation. You will receive CPP disability for the month you turn 65. The month following your 61st birthday, you will receive regular CPP. That is 100% correct. Yep. And just so you know that the change happens automatically unless you tell them not to. It will automatically convert to CPP regular at age 65 unless you tell them not to. Why wouldn't you want them to? Well, you do have the ability to put off your CPP starting until I think age 67. I think that's what the rules are now. So you don't necessarily have to have your CPP start at age 65, but most people do want it to start then. Okay, we got a question here. Let's take a look. What is the process here? I'll hide this. What is the process when the child turns 18? Does one have to contact Service Canada, let them know the child will continue in school and give Service Canada? Yes, you do want to let them know. Absolutely. So What you'll want to do is contact Service Canada and let them know your child after 18 will be attending a college. You often have to get if they your child will already probably be registered with them. So you just have to give them confirmation of enrollment in a full-time enrollment in a post-secondary school, either like a college or a university. And yes, the money does go directly to the child. So they will get the child's banking information or whatever, and the money will go directly to the child. The thing that was coming up that we were just answering the question about earlier is that the person had the problem that they were still gonna their LTD was going to be reduced because of the CPP money that was going to the child, but they were worried the child was just going to blow the money on something stupid, and then like now they're out of money, like they're losing money because their LTD is going down, and the child's getting money and doing something with it, right? So, but that is something depending on the policy, there may not be a way around that. So yeah, the money does go directly to the child at 18. Now, not all long-term disability insurers will reduce it by what the child benefit is, but some do. It will depend on the wording. Okay. Found out today I'm going to be presenting at a conference in the fall in Fredericton, New Brunswick for the Canadian Bar Association, which is an association of lawyers in Canada. I'm going to be speaking on the topic of surveillance evidence and talking about what the current state of the law is in New Brunswick, where it comes to when can you compel an insurer to give you the surveillance evidence, and when can insurers keep it secret and kind of spring it on you at trial. Okay, that's basically what it boils down to. The law is different across Canada. New Brunswick's main cases that the law in New Brunswick has been established through a case from our Court of Appeal. It's getting quite old now, but and there since that case, there has been other cases in New Brunswick that went to the Court of Appeal PEI and Ontario and Alberta. Those cases are kind of moving in a different direction to be more favorable to the injured person or the person with a disability. So where I'm going to be talking about like how are the winds blowing here in New Brunswick? How is it if this gets challenged again? How is it likely to go given these new developments in other parts of Canada? Judges tend to follow trends of how things are going. So if there's a respected judicial opinion in one province, especially Ontario, then other provinces will often follow that same line of thinking and amend. That's how the law kind of grows and changes over time. So this is what I'll be talking about. I haven't written up the paper yet, but when you present at one of these conferences, it's just for lawyers. And I'm one of a number of people. I'll show you the topics that are going to be presented there. Let me bring it up. Let's see what it's going to be. I just got this in the mail, so just bear with me here. Here it is. There we go. Actually, let's not do it that way. That's too hard for me to read. My old man eyes here. Let's do it this way. We're going to share my screen. It'll give you an idea of the kind of things that lawyers do at these conferences. Where did it go? Brochure. Wrong thing. Brochure. Here it is. Brochure. So this will give you something. This is what lawyers do when you go to these conferences. There it is there. Okay. Bingo. Boom. Nope, that's still not right. Oh my dear. Hold on. There. Yes, got it. Okay. So this is what lawyers do at these conferences. So this will be a conference all day on September 25th, 8:30 a.m. to 4:30 p.m. That's a long day. So you can see this is the agenda. This is a strange conference because, well, not strange, but you can see they really limit all the presentations like to 15 minutes. They force you to write this long paper on the topic. They publish all those in a book and give it out. Well, now it's given out digitally. So what it is like it's education for the lawyers. You get the education from other lawyers who come and speak on one of these topics. So when you're there, you will get updated on all these different things. So like trauma informed practice, how to support the survivors of sexual violence during discovery process. That's quite interesting, actually. Discovery process, that's when you are having to give your testimony under oath out of court. So when you see lawyers go to on TV, you will see lawyers around a boardroom table with the little microphones doing interviews outside of the courtroom and recording it. That is what that is. And then we got, what else we got here? We got reining in the expert witness, too far or too much. So expert witnesses are always something that is in flux. That would be a witness who you call to court, like a doctor would be an expert witness, an engineer, somebody who's coming in to give some expert opinion on something. And that is always an area that is the courts look at very cautiously because of how powerful experts can be in these cases. So this is looking like it's going to be talking about how to lock in the scope of an expert's opinion and that type of thing. So when experts are qualified before the trial, you do have to qualify them on what's the scope of expertise they can talk about. So like you can't have a doctor come in and give expert evidence on like engineering things, or even sometimes if they want to give expertise on like vocational, like doctors won't be able to give expertise on some types of vocational opinions because they are not vocational experts. Use of documents in a joint book of exhibits. So when you go to trial, usually both sides will agree to do one book of exhibits. So like when you're at trial and you're doing witnesses and you want to put like evidence to the witness or enter it into evidence for the trial, you agree to put it all together into a book. Now, in the old days, it's printed all out. Nowadays, it's mostly digital, but you do it together just for organization. So this is what Donald Keenan's talking about. Admissibility of expert opinion, reliability of expert opinion. Oh, this guy, he's a bit of a celebrity in the Canadian legal, Eugene Meehan. So he is a specialist. He's a lawyer that specializes only in Supreme Court and Court of Appeal type cases. So if you're a lawyer and I have a client that needs to go to the Supreme Court of Canada for a case, I would hire Eugene Meehan to either do it or to work with me as a co-counsel. That's what he does. His whole practice is just either representing clients from other lawyers at the Supreme Court of Canada or working as a co-counsel on the case. It's so technical to do case. So first of all, it's very hard to get a case before the Supreme Court of Canada. It'd be the same as in the Supreme Court of the United States. Very hard to do. And I know in the US, they have the same thing. They've got lawyers who their whole practice is just focused on, appearing at the Supreme Court of Canada or the Supreme Court of the United States. Always interesting. He's Scottish. He's lived in Canada a long time, but he still has that Scottish accent, and he's a very funny guy. So I'm looking forward to seeing him. Update on the rules of court. Okay, that's interesting. So this is New Brunswick. So we're getting new rules on costs. Wow. Offers to settle. Interesting. Costs is what gets paid when you lose or win a legal case. The loser has to pay the winner's legal costs or a portion of them. So that is one of the downfalls or one of the risks of taking a case to court, is that if you lose, they have a loser pays system in Canada that the loser has to pay some or all of the other side's legal costs, which can be very high. It depends. Provinces handle this differently. In some provinces, the legal costs are just determined as a percentage of what the actual legal costs are for the other side. And other provinces like New Brunswick, Nova Scotia, and others, they use something called a tariff. So it just means that the legal costs that you have to pay to the other side if you lose aren't necessarily just based on what their actual legal costs are. They're based on the amount involved in the lawsuit. So there'd be a chart that says if the lawsuit is about $200,000 in damages that you were going after, then you would follow along and say the legal costs payable in that case is X. It's a low amount of money, but it dictates what it is. It's more around the amount involved in the lawsuit, not what your actual legal expenses are. In Ontario, they look at what are your actual legal expenses and then say, well, we're going to order you to pay like 60% of it. So if your actual legal expenses of the other side was $1 million for a very complicated long case that went to trial, you would have to pay 600,000 in legal fees to the other side. That makes it so difficult for people to take cases to court because no one wants to take the risk of losing and having to pay all that. Defense discovers there's no property in a witness. That is true. There's no property. Witnesses are witnesses. They're open to anyone. Doctor called, plaintiff appalled. Interesting. So I think what this means is they can call. There's no property in a witness. So if the other lawyer could call your family doctor and ask them questions, but without your permission, so to speak, if you're involved in a litigation. Yeah, there's some. I'll have to see what she says when the questioning is proper and when is it allowed. But yeah, partial settlement agreements. Here's an interesting one. What do insurance companies have to produce? So this is Mike Murphy, who's again another well-known lawyer in New Brunswick, former attorney general, politician type guy, but he's always been a very prominent lawyer in personal injury. So what do insurance companies have to produce? So this would be like long-term disability, car accident insurers. He's going to go through like what types of things can we force them to provide us. Artificial intelligence. So you see someone is coming in to talk about that. That'll be interesting just to see how that goes. What else we got here? Instructing experts, revising reports. Yeah, that's always a tricky thing. Sometimes you get the report from your expert and you're like, oh man, they forgot to cover this thing that I needed. So you write back to them and say, look, could you talk? I need you to address this other issue. Well, they revise the report. The law usually works that you have to provide all drafts and revisions of the report. So there's no funny business. They don't want situations where lawyers are telling doctors to change their opinion or to do this. But there is some latitude to say, can you explain this further? Can you address this issue you forgot to address? That kind of thing. Oh, there it is. Surveillance at David Brannen. That's me. Surveillance at a crossroads. Will Maine v. Goodine hold the line in New Brunswick? That's what I'm talking about. Maine v. Goodine is the case that talks about when insurance companies have to disclose surveillance, that they have surveillance evidence to the other side, to the claimant. The reason they want to keep it, so why would they want to keep surveillance? They like to keep it for something called impeachment at trial. So basically the way it works is if the insurance company does not disclose that they have the surveillance, they can't rely on it as evidence at trial. So they can't enter it as evidence of your abilities and these things, but they can use it for impeachment. What that means is if you are up on the witness stand and you are saying things about your abilities and they think that this surveillance evidence directly contradicts what you're saying, they can produce this evidence only for the purposes of impeaching your testimony. It means showing that your testimony is false or that you're lying. Very dangerous thing for insurers to do, because if your testimony is done carefully, it's very hard for them to have evidence that is going to directly contradict it, because often surveillance evidence is not black and white. There's interpretation to what it shows. Again, if you say, like, if your evidence is I've never been on the roof of a house since my disability, and they're like, oh, wait a second, roll out a thing and hit the button, and on the screen it shows you up on a house, like, then yeah, that would be impeachment. That would be good impeachment evidence, but it's often not that clear. So, and we'll see how Ontario goes. The cases from Ontario, like Ionella and Nemchin, those are the new cases. And these cases are moving towards wanting to encourage disclosure of surveillance and not just keeping it for impeachment. But there is a fairness aspect to it. There's nothing worse, like you will go to a mediation and everybody just rolls their eyes. Like the insurance company's lawyer will say, yeah, well, you haven't seen the surveillance, and we're all rolling our eyes like, look, if you had this great surveillance, then just show us. So if you think that this is going to make my client's case like terrible, then just show us. Like, it doesn't help us for you to just say you haven't seen the surveillance. Well, then show us. Like, we don't really care to sit here and have you like speculate how great it is. If it was that great, show us. I've had cases where surveillance has been so bad that I've had to tell my client, yeah, like, we're done here. Unfortunately, like, drop the ball on this one. Like, you really should have let me know. You should have been very careful. Like, if we know, I mean, a client didn't know they were under surveillance, but they were under surveillance doing things that they told me they couldn't do or didn't do. It's just game over. As long as your lawyer knows like what the worst case is, then they can always make a plan to get around it. But when you're caught off guard with things like this, it really can the case can just go to the bottom. Anything around credibility can really be tough, because so much with a disability case is believing you. Like, the only way to know that for you to win is for you to be believed, because there will be certain things that you're talking about, how bad your pain is, and these types of things that can only come from your own evidence. It can only come from your own evidence from you. And if you can't be believed because you've lied about these other things, then the judge will just reject all your evidence as self-serving and of no credibility. All right, let's get rid of this. Oh, we got a question here. My auditor in Columbus, Ohio, nominated me to speak at the Law Society of Ohio. Right on. I was scared to death, but made it work. What were you speaking about? I'm wondering. Yeah, the US and Canada share a very similar legal system, very, very similar. We have a slightly different common law, because when the US separated from Britain through a revolution, they basically started their own case law after that, whereas Canada and other Commonwealth countries, our case law traces back to England, but most of the US case law does not trace back that way. They kind of made a clean break from England for very good reasons. And so there are some differences there, but generally it all works the same way. The same idea, like the US still adopted the British model of, well, I guess not just the British model, but the model of case law, which kind of comes from Rome and the whole way up, and adopted by England in not most Western countries, actually. It's adopted by the Commonwealth countries in the US, all follow the kind of case law model of adversarial courts. Whereas if you get into Quebec and Europe, they have a whole different system there, where they don't use the same adversarial type system that you see in the British Commonwealth and the United States. The one difference I've seen, because I've worked with many US lawyers and done a lot of training and things in the US. I go to not so much recently, but I did go a lot to the US for training years ago. There's a much greater emphasis in the United States on the jury trial. So, especially in civil cases, jury trials are almost like that is a default. is my understanding. And in Canada, it is probably the opposite. It's mostly, they call them bench decisions, where it's just a judge. That is much more common in Canada, whereas jury trials in Canada are less common in civil cases. They're very common in criminal cases, but less common in civil cases that are non-criminal cases. But some provinces actually, which would be unheard of in the United States. And in the United States, there's like it's part of almost, I'm not sure if it's part of their constitution. I think it is. So there is like a ingrained right to jury trials that in the US. In Canada, it is not that clear cut. In some provinces, it's more of a province by province makes the decision. It's not within our constitution to have a right to a jury trial. And so what happens is some provinces have just outlawed jury trials for anything other than criminal or kind of defamation type cases. Oh, you're speaking on property law. Yeah, I don't know anything about property law. I'm not going to lie. All right, well, there you go. So that's what I've covered here today. If I think what I'll do is take a little break here. I'll be back tomorrow for the final session of the week, and then we'll be back next week, back on Monday again. So come tomorrow with your questions, everyone. Great seeing everyone out again. I'll let you go for now, and I wish you guys all the best. Take care.